How you going, people? Continuing on this exigency, confusion, education series. Hope you guys get... Man, these videos that I do like this, I spend a lot of time, and they get real low views. I mean, I'm assuming the majority of my audience likes the cop shooting guns stuff over this stuff. But this stuff is just as important as going out and getting good with your gun, because this is survival after you use your gun, and you need to understand how government is going to come at you and the things that you need to be thinking of when and if you have to use your gun. But whatever, everybody can choose what they want. That's what makes it great. Here we go. Case: Huff versus City of Burbank. Did exigent circumstances justify a warrantless entry into the home of a teenager who was reportedly planning to shoot up a school? The principal of a Catholic high school, Jesus Christ, they're calling the cops. Kid should have said he was in a room with the priest. Anyway, I digress. The principal of the Catholic high school in Burbank notified the police that she had heard reports that one of her students was planning to bring a gun to school and start shooting. The reporting officers met with the principal's sister, whatever, who said she had learned of a rumor. These are all critical terms. Well, I'm saying this because if you just read this like a news article and take it at face value like most idiots do, you're going to come to a different conclusion, which is probably going to be the wrong one. She learned of a rumor that a student named Vincent was going to shoot up the school, and that the threat was supposedly contained in a letter which she had not seen. So basically, we have a principal that heard a rumor about a guy that was going to shoot up the school and supposedly put in a letter, and that's it. The officer questioned sister about the report and learned that Vincent had been absent from school for the past 2 days. Okay? That, as the result of the rumor, some parents were keeping their children at home. So the rumor has not only been heard by the principal, or the principal is telling the parents. We don't know how the parents know, but the parents should have been interviewed of the kids who were keeping their... That would be my question. Okay, you're telling me that some of the parents are keeping their kids home? Which parents? What are their names and what are their contacts? I want to know what they know. I mean, to me, that would be good investigative work, but we'll see. And that she was concerned about the threat and safety of her students. The officers also learned, apparently, from 2 students they interviewed. Okay, so they did interview 2 guys. That Vincent had been victim of bullying. Okay, if he's a victim, that doesn't make him a suspect. Based on this information and Sister Miller's request that they investigate the matter, the officers went to Vincent Holmes to interview him. Okay, I'm okay with this so far. When they knocked on the door and announced they were police, no one responded. That sounds like a smart home. An officer then phoned the residence and could hear the phone ringing. But again, no one answered. Sounds like a smart home. The officer then placed a call to the cell phone of Vincent's mother. Wonder how he got all these numbers. Maybe the school gave it to him. Maria Huff. She answered the phone. But when he explained that he was the police, that he was a police officer and that he wanted to talk to her about Vincent, she hung up. So, I'm okay with that too. About 2 minutes later, Maria Huff and Vincent walked outside and stood on the front steps. Bad move. Had they stayed in the house, the cops would have had to go get a warrant because they didn't have enough to kick the door under exigency. But now they have moved into a public place, and they're going to probably end up talking to the cops, which means the cops are going to be able to establish and to get more probable cause, reasonable suspicion, fear for their life, fear for the students, and then they're going to be able to act easier without a warrant. Don't talk to the cops, people. When one of the officers explained that they wanted to talk about some threats at school, Vincent responded, "I can't believe you're here for that." Another officer asked Maria Huff if they could go inside and talk. Oh my God, are you kidding me? She said, "No, good move, why the hell did you open the door and walk out and talk to him? I mean, it sounds like the woman is kind of trying to make some good moves, but she keeps screwing it up. But she said no. The officers then asked her, see, she's talking to them, if there were any guns in the house. At which point, she turned and ran. Actions. Officers get to interpret actions. She turned to the house and ran into the house, followed by Vincent and the two officers. So they gave chase. Hot pursuit. In a public area. Fear for safety. I was worried. It came about guns. Here we go. I mean, she screwed up when she walked outside. When one of the officers was asked at trial why he entered the house, he testified it was because of, again, the threat that he was going to blow up the school or shoot up. I never heard anything about blow up. Cop just threw that shit in on the sign. Or shoot up the school. I wanted to make sure neither one of them could access any weapons. Why? Did they commit a crime? Why couldn't a mom access a weapon? You took away mom's Second Amendment rights because a school heard a rumor? That's bullshit. I want to make sure they couldn't access weapons from inside the house, and that's where they normally get weapons from, is either their parents or relatives or friends. Okay, sounds like a good, reasonable statement that could be made in a crisis, in the heat of battle, in the spur of the moment, in a rapidly evolving, tense situation. Okay, I get it. After entering, the officers remained in the living room for 5 or 10 minutes. The court did not say what happened during this time, except that the officers did not search anything. So they ran, violated no warrant entry, got into the house, but they didn't feel the need to search the house for guns. Did not search anything, and they left after satisfying themselves that the rumor was not true. Okay, so on one point here, the cops didn't overexert, and I'm not sure if I would have chased them in the house or not. I mean, I would have to be there. You know, sometimes cops don't articulate everything they're seeing or hearing. You know, did they look like? Was there an eye contact saying we got to go or get the gun? I mean, you know, again, I don't know if we heard dad in there, if somebody heard a racking of a gun. None of that shit was said. You would think it would be said, but so I can't really say if I'd have followed him in or not. But based on what I'm reading here, I don't know, man. When somebody runs from me when I'm talking to them about guns and safety, the hair on my neck kind of stands up a little bit. So I'm not sure on that one. But once the cops entered, they didn't push the issue. They didn't search and destroy the house. They didn't violate their rights. They actually must have asked good questions that satisfied that the rumor wasn't true, which says a lot about the officers. I'll give them credit for that. The Huff family later sued the officers in the city and federal court. Now, when they say they sue the officers in city and federal court, the officers can't get sued because they have liability. Really, they're selling the city because they want big pockets with taxpayer money. And the officers are just the agents of the city and the friendly witnesses. So as long as the officers still work for the city, they're going to help the city win the lawsuit. If the city fires the officer, now the officer can testify against the city as far as training, hiring quota hires, not having a standard, etc. Okay, federal court seeking money and damages, claiming that the officer's act of entering the living room without a warrant constituted a violation of the 4th Amendment. I kind of agree with that. Following a bench trial, the district court ruled that the officer's entry was justified by exigent circumstances. The Huffs appealed to the Ninth Circuit. Discussion. A warrantless entry into a home is permitted under exigent circumstances, exception to the warrant requirement, if it is objectively reasonable, and is objectively reasonable if the need for the action outweighs the intrusion. We've heard this before. These are the things that the courts will always observe when exigency becomes an issue or in question. But because a warrantless entry is such a serious intrusion, good. I'm glad it's a serious. It should be a serious intrusion. The Ninth Circuit and other courts have ruled that it cannot normally be upheld on the basis of exigent circumstances unless the officer had probable cause to believe it was necessary to diffuse an imminent threat to life and property. I don't think they have that here. They might have hot pursuit, because they ran from them in an interview, but they weren't in custody. They voluntarily came out. So I don't even think they have that. The question then is whether the facts known to the officers when they entered constitute probable cause. I think they could have got a warrant to go search the house. So I think they did have probable cause. I haven't read this yet, but I don't know what's going on. I kind of glanced through it, but I have no idea what's going to happen. So did they have probable cause? You need probable cause to get a warrant. But remember, in probable cause and warrant, all I have to do is say I have a fair probability of finding evidence. So I think if I went to a judge and said, Your Honor, there's a school principal that's afraid that the kid's going to shoot up school. She gave his name. When I tried to contact them, they wouldn't answer the phone. They wouldn't come to the door. And I can't get in touch with them. I want a warrant to go into the house to make sure and secure any guns in case there are guns in the house, because from the information I have now, which is from the principal and students, and some parents kept their kids home, that I think this could be a credible threat, and I want to secure any weapons in the house. Now, there's really not a law that says I can go in and just take weapons because I have a feeling or something. But I think a judge would have gave that warrant. Again, when you get a warrant, you have to state a crime, and then you have to find evidence of that crime. If he really wanted to get a warrant for this, you should have put in a warrant that I believe there is a letter that he wrote on his phone or on his text or sent from his computer or printed, or that he showed one of the students, and I think that letter is in his home. And if he's threatening to shoot up the school, that's a crime, and that letter will be evidence of a crime. And I think he would have got a warrant. But they didn't do that. So anyway, if they had probable cause to get a warrant, though, then they had probable cause to do this. The court in Huff ruled that probable cause did not exist for two reasons. First, none of the circumstances that it considered relevant demonstrated a sufficient threat. I kind of agree with that. So far, all we have is a rumor from a principal. Second, an officer testified that he did not think that probable cause existed. Whoa, an honest officer. Good for him. Look, I don't know why cops lie on the stand. It's like, I don't give a shit. So what? Either we did something, we didn't. The truth is the truth. Why get up there and try to lie? It's going to come out. You're going to have to tell another lie to cover it up. You ruin your credibility. Why get up on a stand and lie? It is what it is. So what? I didn't think we had probable cause. If the officer said that, good for him. Now, the DA was pissed that the officer said that and said, dude, why would you say that? Why wouldn't you keep your mouth shut? Why wouldn't you say you weren't unsure? And I've had conversations with that. And my answer to the DA would be, because it's the freaking truth, and that's what I thought, and that's what I'm telling on the stand. And if you want to get on a stand and get sworn in, then you get to tell your story. How about that? Because lawyers will never get on a freaking stand. They like to sit around under their protection of I never have to swear in so I can lie and bend the truth and twist the truth. But anyway, I digress. Having also ruled that the two officers who entered the residence were not entitled to... Wow, man. Nice circus. Really got it good here. Not only did they say they didn't have probable cause, but they stripped them of their qualified immunity, meaning they can be held liable. Now, even when a cop loses liability, the taxpayers pay the bill. I told a case where the DA got sued for threatening a guy to fire him, told him he better quit, or he would fire him. The attorney quit, and then the attorney sued him. And the attorney won. And they got punitive damages because of what the DA did. And they punitive damages have to be paid out of the personal account of the person that they were addressed to. So the court said, DA, you were so egregious in what you did, you're going to pay punitive damages of $6,000. Well, the DA came back and goes, I ain't paying it. And the county goes, okay, look, here's what we do. You pay it because we have to follow the court order, and then we're going to give you a $6,000 bonus, and that way we'll pay it. So the taxpayers paid it, but as far as anyone else knew, he paid it. So even when officers have to pay and they lose their immunity, the city picks up the bill. Anyway, I digress. All you pesky citizens right now with your mouth open going, oh, I didn't know that. Well, no shit, because you're not in a freaking system. All right, qualified immunity because it's clearly established probable cause. The court ruled that the case should proceed to trial. Okay, let's go to some comments here and see what we got here. There are several things about this term that demonstrate confusion by the court. Okay, obviously this is a DA writing this and he doesn't agree with the court. Over the facts of the case and the applicable law. For starters, It appears that the court did not understand the district court's ruling on the matter. On 2 occasions, it explicitly acknowledged that the district court had ruled that exigent circumstances had in fact existed. After holding a 2-day bench trial, the district court held that exigent circumstances permitted the officers or the police warrantless entry into the Huff's restaurant, and later the district court found that the exigent circumstances justified a warrantless entry into the house. And yet the court began its analysis by saying it is not clear whether the court actually found that there was exigent circumstances. Okay, if that's true, that's a conflict in the court. Guess what? Doesn't matter. The court, the judge, the lawyer with a robe gets to do what he wants. That's why when people tell me, oh man, you got to know the law and I know the law and you don't know what you're talking about. Okay, whatever. This is why you need to be like a midget at a urinal, always on your toes when you're dealing with government. More troublesome, the court misrepresented a crucial piece of evidence, saying that Miss Huff, when asked if there were guns in the house, merely responded that she would go get her husband. She then turned around and went into the house. But in reality, she turned and ran into the house. So, obviously running seems more consciousness of guilt or nefarious, so to speak. But so what? She wasn't detained. She wasn't under arrest. I can't run. If I'm jogging and you walk up and then stop and I keep jogging away, are you going to say, he ran away from me? I mean, that's where we're going when you let government get out of control. As a dissenting judge pointed out, the district court found that when asked whether there were guns in the house, rather than responding, Miss Huff turned and ran into the house. And as one of the officers testified, it was this unusual and highly suspicious action that precipitated the decision to enter. Nice terminology, officer. This is an experienced officer that knows how to use his lawyering silver tongue shit. It was an unusually and highly suspicious action that precipitated the decision to enter. So I thoroughly contemplated all the things that I had, and in my quick assessment of the situation, I felt a fear for me and possibly the school and to the child itself, because he could have shot himself, that I felt I had to enter to preserve, protect, and serve, to keep people safe. All right, in addition to distorting the facts, the majority failed to apply the correct legal standard in determining whether probable cause is. The Supreme Court has repeatedly instructed the lower courts they must consider totality of relevant circumstances in making a determination. And they must also isolate the facts upon which the officers relied. Now that is true. You can only base your decision on what the officers knew at the time that they made the decision, not what they found out later. Belittle the importance of these facts and try to explain them away, and then announce that probable cause did not exist because none of the abstract facts were sufficiently incriminating. And yet, this is exactly what the majority did. Oh man, bad majority. For example, the fact that the Huffs did not answer the door of the phone was casually dismissed by the courts. So what? They don't have to answer. That the Huffs did not answer their door or telephone may be unusual, but it did not create I agree, it did not. But no one was contending that these circumstances created exigency. Instead, they were among the many facts, totality of circumstances, that the officers could rightly consider in making their determination. The majority then compounded its error when it said the district court was incorrect in finding that Mrs. failure to inquire about the reason for the visit and her reluctance to speak to the officers and answer questions were exigent. Okay, so if they said that, which I agree with, they'd probably say, look, her failure to answer, she didn't want to answer doors, she didn't want to answer phones, she hung up on us, she ran back in the house, all that tells me she's guilty. Okay, but the district court did not rule on these facts were exigent circumstances. Facts were exigent circumstances. It merely ruled, as required by the Supreme Court, that there were facts that the officers could rightly consider. Not only did the court ignore the Supreme Court totality standard, it also ruled that the probable cause did not exist because the officer testified he did not think it did. Now, I've had courts before rule, even though I didn't think or another officer didn't think, they said the facts were there and it was error. So even when the cop doesn't think he should act and he acts inappropriately, the courts can say, oh, we think you did okay because we think you had it. And yet the officer's belief That he had or did not have probable cause is absolutely irrelevant. As the Fourth Circuit pointed out in its related context, the Supreme Court's definition of probable cause asks not whether the arresting officer reasonably believes that the arrestee has committed a crime, but whether the evidence was sufficient to support that reasonable belief. So even if the cop doesn't believe it, the cop now has been so dumbed down to where you can be an idiot, you don't even have to connect the dots and have to admit that there's probable cause, because the courts later may find that the evidence supported it, so it doesn't matter whether you're an idiot. Wow. All right, let's see what goes. Because the majority neglected to properly consider the totality of circumstances, we will do so here in the circumstance. So this is the DA making the court look like they screwed up and maybe setting up an appeal to the Supreme Court. Although the threat to shoot up the school was unconfirmed, sister, who was apparently equating with Vincent, said she was concerned about threat and safety of her students. So what? She's concerned. Okay, that's not enough to violate somebody's right. That's one incident. And this is what people do a lot when I do these videos. They'll come back and they'll quote one thing I said and say, that's bullshit, man. That doesn't count. This in and of itself does not count. But all these 10 things together is what's called totality of circumstances. 2, the officers were aware that Vincent had been a victim of bullying. Okay, so why is that relevant? Because many times in these school shootings, we see that victims of bullying had enough, and that's when they retaliate, explode, and come back and exact revenge on the other students. So I think that's relevant, although that in and of itself is not a crime. Number 3, as a result of rumors, some parents kept their kid away from school. Rather drastic response unless the parents had reason to believe it was more than a vague or malicious rumor. Well, I don't know if I agree with that. A parent can keep his kid home, and I think a smart parent does keep it home if they hear rumors. What the hell? Why not err on the side of safety? Why send your kid into school when something may happen, especially when you hear something may happen? So I don't know if that really applies, but you can say that some parents believe the threat was real because they kept their kid. Okay, not in and of itself much. Vincent had not seen his school path. It appears that's what I explained. So what? That in and of itself, not a big deal. Although the Huffs were home when the officers arrived, they did not answer their door when the officers knocked and announced they were police officers. So what? That sounds like smart. More people ought to do that. Cops ought to know. Cops ought to expect when I knock on the door in uniform, people aren't going to talk to me anymore because we have totally destroyed that we work for the people and we're here to help. We have totally become a tyrannical existing army where we go out and all we're trying to do is collect taxes, arrest people, find ways to resist, and exert our authority. We ought to expect, as police officers that run around and do tyrannical shit all day, that people, good people, don't want to talk to us anymore. But I digress. The Huffs did not answer the phone of their home when the officers called. So what? A lot of people don't answer phone. Nothing. When Maria Huff answered her cell phone and was informed the officers want to talk to her, she hung up. So what? Everybody ought to hang up when cops say, I want to talk to you. After Maria Huff exited the home and learned the officers wanted to talk to her about threats at school, she did not inquire about the reason of their visit or express concern that they were investigating her son. I think that is suspicious. I think this is relevant in the totality that we're here to talk to you about your son and you're not asking why. That seems kind of odd to me. And you know what? I'm paid to be suspicious when there's nothing to be suspicious about, and this would make me suspicious. I think it would make most reasonable people suspicious, but maybe not. I mean, there'll be some people here that are like, man, that's bullshit. You're just kissing the cops' blue line. Whatever. Freaking idiot. The officers could have reasonably inferred, when you start inferring, officers can infer anything, that Vincent Huff had inadvertently acknowledged that there were some factual basis for the rumor when after an officer informed him of the threat, he responded, I can't believe you hear about that. That doesn't corroborate there was a threat. That just corroborates that somebody's accusing him of a threat. But it does progress in the investigation. And when asked if there were any guns in the house, himself turned and ran inside. Okay, keeping that in mind with each additional suspicious circumstances, with each coincidence of information, the changes of having probable cause increase exponentially. It is apparent that the Ninth Circuit erred when it held that the officers did not have probable cause in their house for their safety and the safety of others. Bum, 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 bum. Okay, for their safety and safety of others. Man, those police, they're always there protect people and keep them safe until they're shooting and killing everybody. Even more inexcusably, the court ignored the seriousness of the investigation into a report that a student had been planning. So what? We have a report. We have no letter. We have no corroboration. We have merely rumors. Rumors can happen all the time. Had been planning to commit a mass murder of schoolmates. All we heard was the shooting. Now it's a mass murder. A few minutes ago, it was a bomb. And it expressly absolute no sympathy for the plight of sister or the officers involved. Oh, so the pesky citizens should have been sorry and should have showed sympathy for the poor officers that had to do their job, and for the poor sister that listened to the rumors, and for all the kids that were tormenting her kid, that she should feel sympathy for everybody. Really? How about feeling sympathy for the pesky citizen that's got her kid at home because he's being bullied, and she just wants to put time behind it, and now the cops are showing up, chasing her into her freaking house? How about a little sympathy for the pesky citizen? All right, expensively explosive matter while keeping everyone safe. Woo, I love those safe words, man. Woo. But while the tactics and methodology of the nice circus were, to say the least, shabby, man, he's just insulting the shit out of them, the actions of Mr. and Mrs. Huff were contemptible. This entire sordid affair was triggered by their immature and irresponsible response to the officers. Wow, legitimate inquiry. So not only does this DA hate the court because it ruled against him, he hates the pesky citizen for being contemptible against their power and authority and their great position of honor as a DA and as a police officer. We should bow down and kiss them and thank them for keeping us safe. Whatever. All right, immature response to the legitimate inquiry, and then as if to display their atrocious, I don't know what that is. To the general public, they sued the officer, so they're pissed that they sued. Let's see if I can look this up real quick without getting in trouble. Rick, of course. Normally it comes right up with the word. Now I got to go to this. Boorish, curlish, loutish, clownish appearance. All right, not sure what the hell that. Why he threw that? He basically, maybe he's just calling him a clown. To the general public, they sued the officers and the city, hoping to make some easy money. The whole thing is just disgusting. Wow, that pesky DA just really hates and has contempt for the pesky citizen, don't he? All right, this one went a little long. All right, lots of issues. Remember, all the people that come here and tell you, man, they can't do that. That's extra circumstances, and they can't do that. Or all the cops that'll come here and go, man, they were in fear of their safety. They can go in. It's never easy or clear, people. Than the people that make complicated subjects like this simple and easy and always have the right answer and all the info. Usually they're full of shit. Rick, you can't say that. Well, I just did. All right, well, in that there.